Hello, everyone. Thank you for joining us today for the webinar on navigating insolvency risk for in-house counsel, a combined offshore and onshore perspective. My name is Rahul. I am the publisher at In-House Community. Now, before we start the presentation, I'd like to make some important points for all the attendees. At any time during the webinar, if you have any questions, please type in these questions in the question or the chat window on the control panel of your GoToWebinar. And we'll make sure that our speakers receive these questions right away. Now they can choose to answer these questions then and there, or they will answer these questions right in the end. We have some time allocated for Q&A. We also have some quick polls which we may invoke during the webinar. So please keep an eye out for these polls. There'll be a question and 4 possible answers. You have to pick the right answers. Now, if you don't get the right answer, that's not a problem. Don't worry about it. We are not going to disclose your answers in public, and especially not put them on LinkedIn. So you're safe. At the end of the webinar, there will also be a short survey, which we ask everyone who's attending to fill. It's not going to take too much time. Lastly, if you need a copy of the slides from the presenters, we will share their information with you, their email IDs as well, and you can directly get in touch with them and ask them any questions or get a copy of the slides. Now, today's webinar has 2 sessions. The first one will be about external insolvency and how to deal with a defaulting counterparty. The first session speakers are Michael Paderit and Jeremy Lightfoot. Now, both these partners are from the law firm Carey Olson. So I'll ask Michael and Jeremy to switch on their webcam whenever they can. Michael's practice concentrates on the formation, operation, and restructuring of private investment funds, primarily private equity and venture capital funds and their related fund sponsor vehicles. Michael also represents early and later stage companies in a range of industries, including fintech, life sciences, and technology, in relation to private financings, listings, cross-border investments, and other M&A transactions. And Jeremy is a partner in the dispute resolution and litigation practice. His practice is focused on high value and complex commercial and corporate litigation, insolvency, and restructuring matters under the laws of the British Virgin Islands and the Cayman Islands. Thank you very much, Jeremy and Michael, for joining. We can see you. Great. The second session will discuss internal solvency for restructuring options and managed wind downs. Hi, Eloise. So Eloise Matsui, who you can see on your screen now, she's the presenter for the second session. She's a partner in Stephenson Harvard's Hong Kong litigation team. She specializes in restructuring and insolvency matters. Her areas of practice also include general commercial litigation and regulatory litigation. She has a cross-border expertise working with clients from a number of jurisdictions outside of Hong Kong. Well, that's it for me. And now over to you, Jeremy and Michael.
Thank you very much for that introduction. And thank you also to everyone for joining us and providing your feedback as to which sessions you particularly were interested in. With that in mind, we're going to tailor our presentations to make sure they're as time efficient and as relevant as possible. As you've just heard, we're going to start by talking about external insolvency. Now here we're talking about the situation where a counterparty you're dealing with is insolvent and defaults. This is increasingly common in today's climate, and it can lead to some complex decisions. We've identified 4 areas, and perhaps if I could have the next slide, we've put them out there on there for you, a couple more slides on, and we'll show you the 4 key areas that we think it's important to be thinking about in today's climate. So these are set out on there. You are finally got it there, the 4 topics. I'm going to jump straight into the first topic because I know there's an awful lot of interest about that. So if I could have the next slide, please. Share charges remain a popular tool. The security is great on paper, but realizing it can be a challenge. Now, the analysis always starts with documents. Usually your charge documentation will be carefully drafted and will set out a list of the remedies that you have. But the key point is that's the list of remedies that the person who wrote the document intended you to have. The remedies you actually have is a much more complicated situation. The documents only ever tell part of the story. You need to be looking at the law governing the share charge itself, the laws of the jurisdiction in which the company is incorporated, the laws of the jurisdiction in which the share register is held, and also then finally the laws of the jurisdiction in which you're actually going to take any steps. So it can be a multifaceted juggling act, as I know a lot of people who are attending already know. So setting the strategy is key, it's everything. So let's start by having a brief refresher of your potential rights under a share charge before looking at how we recommend you to go about setting your strategy. So there on the screen, you've got the four kind of key classical rights that you may have under a share charge. Now, obviously, every share charge is different, and you need to look at your particular documents and particular systems of laws, but these are the four that tend to keep coming up. So a brief run through them. If I go back to the slide before, please, on the taking possession, this looks like a kind of a comprehensive self-help remedy sitting on a plate. And it's not unusual to have a pack of deliverables which on paper allow you to take possession of the shares. But these steps do come with a health warning. All that this does is put the asset into your name. It's not the end of the story, and it doesn't mean that without more you can take and keep the assets. So possession is a useful control step, but it's not an outcome in itself. And there's also collateral effects of taking possession. You will need to deal with the asset in your accounts. You may have to consolidate the accounts of the company. If you're a financial institution, you may need regulatory permission to take ownership of those assets. And indeed, your own constitutional documents may control whether you're allowed to own these types of assets. And even theoretically, you become a shareholder, so you are liable for any liabilities of the shareholder, as remote as that may be. So possession it's a useful control step, but it's not really the panacea that often it looks like from the documents. And the power of sale, second on that list, this is a really powerful remedy that you will often see. Carefully exercised, it can be a swift route to a self-help remedy. You have to look at the particular terms, but generally the things to be having in mind are the importance of acting in good faith, acting fairly towards your borrower, making sure that you use best efforts to get the best price reasonably obtainable. And obviously you have to be very careful with how you deal with the proceeds of this sale, how they're allocated between the different liabilities. And finally, of course, you've got to be really careful about who you sell the asset to. Great difficulties occur in a lot of jurisdictions if you attempt to sell the asset to yourself. So it's a powerful remedy, but it comes with a lot of responsibility. And I think it's for that reason that we see a lot of people preferring to use the receiver route, which is the third one on that list. Now, receivers can happen in many ways, but basically they can be court-appointed or contractual. And a lot of well-drafted share charges will give you a contractual right to appoint a receiver. This has clear advantages. It allows you to swiftly take control of the assets without the complications of possession, and allows you to have an independent professional to help you realize the value of it. It limits the possibility and even indeed the probability of any challenge to your actions. And where it's contractual, it can be done swiftly and often without even needing to go to court. It can often be done as a self-help remedy. So unsurprisingly, we do see in the market that a lot of people are interested in taking this route. And finally, on this summary of the classical enforcement rights you can have, the foreclosure one, it's put at number 4 for a reason. This is rarely used. What we mean here is essentially the taking and keeping of the shares. It's cumbersome, it's slow, it usually requires a court application to extinguish the equity of redemption. So it's not an attractive remedy in most situations. So going on to the next slide then, those are the 4 kind of key things that you might be able to do. Well, how do you decide which strategy to adopt? Well, the answer on that actually doesn't come from leading academics, it doesn't come from leading lawyers. The actual answer comes from Richie McCaw, who was the very famous captain of the All Blacks rugby team. Now, as many people might remember, he famously lost the first World Cup final that he captained, and he realised afterwards that they'd gone about their preparation all wrong. They trained by playing well. They trained and refined their skills by being successful and getting better and better. But what they hadn't done is practice for how to play when you're playing really badly. They hadn't practiced for what to do when everything goes against you, when there's an unexpected catastrophe in what you're trying to achieve. And that's when it's the hardest to do your job, and that's when you really need the training. Well, that's the answer on security. The answer on security is to have a pre-default review, to do this work before anything goes wrong. We often get enforcement questions when the default has occurred. It's urgent. Assets are under threat. There are competing interests against your counterparty that you're going after. The position evolves rapidly with news leaking out. Banks take aggressive steps. People swipe assets. You need help in many jurisdictions simultaneously. It's tough. But if you do a pre-default health check on your security, that can be invaluable. It allows you to check that everything is in order. You can fix things if you find any problems, which is really useful. And then you have a simple roadmap of your options that you can put in the file. When this happens, when the default arises and when it's urgent dash for an assets around the world, everyone's scrambling to get ahead of the crowd and get advice and get lawyers instructed, you can be relaxed. You can simply dig out of your file the roadmap of the options you have, look at the situation you've got, and choose which one suits the particular situation that you're facing. As to what those likely decisions are going to be, it's what powers you're going to use. We see, as I put on the slide there, the real decision is whether you need control of the assets, realization of the assets, or possibly both of them. You might need control, the possession type steps, if there's a threat to the assets, if they're deteriorating, or if there's a risk of them going astray. Similarly, you don't always need realization of the assets. You don't always need to get the value out of them. It may be that in your particular circumstances, simply holding the assets for a while, giving your counterparty an opportunity to raise funds, that can be enough of a solution. And also, one of those important decisions to make is whether to be self-help or go to court. And this is often portrayed as being a very important decision to make. That speed and efficiency often favours self-help. People often say that certainty favours going to court. A well-drafted security document will often give you these self-help remedies, but we regularly find that the true decision that you actually have to make is, what do you need to do with the assets? Do you need control? Do you need realization? And when you fix that strategy, the question of self-help or court usually simply falls to be determined to decide what's needed to achieve this strategy. Is it mandatory to go to court? Well, then you need to go to court. And so it's not so much as a separate decision as simply one part of your overall strategy to use the assets. So as you've seen, and you probably already knew, share charges can be very powerful. They do give you a swift and effective remedy, but it is a complex process. And the one takeaway we'd say on this particular topic is, if you have any opportunity to do a pre-default review, please do, and it will save you a lot of time and angst in the future. Then moving on to the next slide, what if you fancy
Jeremy,
yes,
can I just add a little antidote then? I was talking recently to a professional insolvency practitioner, so one of the people that would regularly take an appointment as receiver, and they said they got urgent instructions from a creditor. We want to appoint you as receivers. We're going to be appointing you tomorrow. And they were only when they were, running their conflict checks and asking for the documents, and they said, can we get a copy of the share charge? And then they received it and they saw there was no power to appoint a receiver. So that's just an example of someone, going straight into the enforcement without doing any pre-enforcement strategy. They assumed they had the right to do something, but it wasn't there. And I think just re-emphasizes your point that it's worth taking the time to plan and see what your documents allow you to do in advance, so that when you're in that tight, urgent time period, you know where you are.
Yeah, no, that's a really good point, a really good example. And we've even seen situations where, yours is pretty bad, but we've even seen situations where actually it's the receiver who comes to you and asks for assistance in doing his job. And it turns out when you actually look at it, there wasn't any power to appoint them in the first place. And so I think that's the thing, is that there are all these remedies that everyone's used to seeing, and they're usually there, but not always. And even if they're there, depending on what combination, because I mean, we're talking about BVI, Cayman and Bermuda laws particularly here, and Eloise, you're kind of coming from the Hong Kong law perspective. And even within our own little pool of jurisdictions there's quirks about how you have to go about appointing a receiver, and when each law defers to the other law to determine certain questions. So I think I agree entirely that if you at all have an opportunity to do it, it's really time well spent. So thank you for that. So just moving on then, if receiverships aren't for you, if you fancy a completely different strategy, I'll deal very briefly with the concept of winding up your counterparty. And this is something Eloise is going to be talking a little bit more about winding up over in her session. So the typical scenario here is it's pretty similar in that you have a defaulting counterparty. This time you think they're probably insolvent, and we'll use that term very loosely. I will just say insolvent within the terms of the relevant jurisdictions. The key point here really is how to identify the best time to act. You're really looking for that Goldilocks moment. Too soon and you're going to incur really substantial costs and efforts. You might harm your counterparty, and you certainly will harm the relationship you have with your counterparty by acting too soon. But if you act too late, there may be nothing left to recover. So in our experience, a couple of markers you can kind of look out for that might suggest it's a kind of situation where you should be thinking about winding up your counterparty are things such as kind of repeated pressure not working. Perhaps you're being strung along with promises or glancing correspondence. Someone who's regularly communicative isn't anymore. If you see your counterparty's position deteriorating, that's usually a red flag. If you see other creditors taking action, maybe swiping assets, secured creditors moving in, maybe you're even concerned about how your counterparty is being managed. Maybe you're concerned about the propriety of transactions, any recent large dispositions or kind of loans being granted. Anything like that generally will be red flags to say it might be time to start looking at the insolvency route and the winding up routes. The advantages of this strategy are pretty clear. It's a very serious step to take. So for the same reason, it's not one the company can ignore. They have no choice. They have to engage with the process. And if it works, it usually leads either to swift payment of your debt or to an independent professional being appointed to manage the liquidation. As to how it works in practice, for such a serious matter, it's a relatively simple procedure in most jurisdictions. There's an application stage where you go to court and identify the grounds for the insolvency and you're standing to be there. Provided the judge is with you, you then go into the appointment stage where the liquidator goes about finding the assets, realizing their value and distributing them according to priorities. I know that a forum is something that often is presumed on these matters. It's presumed that you need to go to the forum which the company's incorporated. That's not always the case. I don't know, Eloise has a lot of experience of this, but in Hong Kong, for example, you can wind up foreign companies, and if it's the case that the assets are here in certain circumstances, that might be easier. And so finally on here, just common pitfalls of this. The things that we find that people get most frustrated about for winding up counterparties is, of course, it's a collective process. It's no longer just you enforcing your security or you enforcing your rights. It's for the good of all creditors. And with that comes quite a considerable loss of control. And alongside that, I think the key concern normally is how much is there in the pot. If the assets are limited, you may well find that the secure creditors scoop the pot, or in an extreme circumstance, you might find that the liquidator's fees exhaust the pots. So it's important when kind of thinking about winding up a counterparty, not just necessarily to look at whether you can, but also to look at it from the other end and see whether it's really worth your while. So those are kind of a couple of the big ticket topics we're seeing at the moment. I'll now hand over to Mike to carry on, and he's going to be looking at the contractual outs, which I know from the survey was also a very, very popular topic.
Thank you very much, Jeremy. So yes, as Jeremy just mentioned, given the responses to the initial survey, it seemed overwhelmingly that people were in support of hearing more about the understanding the contractual outs section, and there was really not much interest in the section on defaulting limited partners. So I'm going to focus most of my time on the first section. To the extent that there are questions or people are interested in the other section, I'm very happy to take that offline and talk with people separately. So diving right in here, an area which has generated a lot of interest of late for us has been in relation to contractual mechanisms to delay or suspend performance of contracts or to terminate contracts entirely on the basis of deteriorating operating conditions or events outside of the control of contracting counterparties. So focusing firstly on material adverse change provisions, these are quite common provisions in agreements relating to general commercial acquisitions, SPAs, public and private M&A type transactions. They're also very common in financing documents and arrangements. In practice, depending on their scope and exact wording, a material adverse change or a MAC provision, as I'm going to call it, in an acquisition agreement would give a party the option to terminate the transaction or to reprice the deal. In a financing arrangement, the MAC clause will often take the form of a material adverse effect event of default, which is really a catch-all event of default, which wasn't specified or anticipated at the inception of the facility. The effect of invoking the clause is that if the event continues and is not remedied, the lender will either not be obliged to make the loan or can accelerate the repayment of a loan that's already been made. So MAC provisions and events of default are often seen as a catch-all, as I mentioned, for events which are unseen at the time of an inception of the arrangement, and they operate in addition to any express termination or amendment provisions in the agreement. Just to give you a sense of the flavour and what the drafting of these terms looks like, in very general terms, of course, in an acquisition agreement, they will generally refer to a material adverse change in the business, operations, assets, liabilities, condition, whether financial, trading or otherwise, of the company, and sometimes also of the group of companies. For finance documents, they'll generally also include, in addition to what I just mentioned, the inability of an obligor to perform its obligations under the facility agreement, and will sometimes also go on to talk about the validity, enforceability, effectiveness or ranking of any security granted in connection with the facility agreement or the rights or remedies of a lender. So as you can see, they can be quite broad and they can really encapsulate a lot of different situations which would not have been foreseen at the time of entering into the arrangement. So as I mentioned, what constitutes a material adverse change for the purpose of the agreement is generally detailed in the agreement itself, rather than having to look at the law of the governing law of the agreement. So absent.
You're lucky you don't have to give 5 jurisdictions.
Just focus on the agreement, yeah. Keep it simple.
Much better.
So it's absent any express drafting in the agreement itself. Parties will generally want to focus on the nature of the change being relied upon, whether the change was foreseeable at the time of entering into the arrangement. The materiality of the change will obviously also be very important. So the case law currently suggests that the change need not be one single event or occurrence and could be the result of a cumulative deterioration in the financial condition of a party. So it's obviously clear that these provisions are very, very fact specific, depending on the arrangement that the parties have entered into. Just a word of warning or a word of caution, MAC clauses are not all created equally. They do need to be considered very carefully, as the triggers will depend on the drafting, as we've discussed. For example, it's often the case, and particularly in financing agreements, that the relevant event or condition need not objectively have had an adverse effect at all. So here a subjective standard is introduced, and a common construction, particularly in financing agreements, is that the borrower has, in the opinion of the lender, suffered a MAC event, which obviously means it could be sufficient that the lender believes the event had a material adverse effect on the borrower, and for the belief itself to be honest and rational. The objective approach is much more common though in acquisition agreements. And if the provision is silent as to whether the occurrence of the event is to be determined subjectively or objectively, then by default an objective test will be applied. In terms of the impact on transactions, if validly invoked, the effect of a MAC provision or an event of default in a financing arrangement is to terminate the transaction, accelerate the payment on a loan agreement, or to act as a draw stop to stop a lender's obligation to loan funds. So on their face, these are very useful provisions for lenders and for buyers, but they're also somewhat fraught as their interpretation can be very uncertain and the consequences of improperly invoking the provisions can be quite severe. So to give you an example, say take a lender improperly invoking a MAC clause could well be sued by the borrower for breach of contract and also damages to put the borrower back in the position it would have been in had the lender performed its obligations under the facility agreement. So in practice, given the risk of challenge and the potential for counterclaims, these are not commonly invoked provisions. However, they are often used as a tool to bring the parties back together to renegotiate the terms of the deal. And also in these current uncertain times we're facing, we've received a lot of, or an increase in client queries looking closely at the MAC provisions in their agreements, and I think that the use of them may increase over the coming months and years. One really prominent example which made the financial press recently was in relation to the acquisition by the Swedish private equity firm EQT of MetLife Care, which is a New Zealand-based retirement village operator, in a deal which was worth roughly $900 million. In that deal, EQT invoked the MAC clause to terminate the deal completely after MetLife Care's share price fell by about 50% after the deal was announced. So MetLife, this is currently before the courts in New Zealand, MetLife Care is seeking specific performance and alleging that EQT has breached the agreement. So you can see here's one of the pitfalls of this particular approach, in that it's very often open to challenge. So let's move along to talk about force majeure provisions. What are they? These are provisions, a force majeure provision is a contractual term by which, can we just go back one slide? The force majeure provisions are a contractual term by which one or both of the parties is excused from performing an obligation under the contract in whole or in part, or is entitled to suspend performance or to claim an extension of time for performance upon the happening of a specified event which is beyond that party's control. Under English law, unlike French law, the concept of force majeure is not codified, and the law doesn't define exactly what is meant by force majeure, and thus the triggers, exceptions, and meaning of the concept for documents governed under English law are entirely dependent on the wording of the particular agreement. The quite standard wording for a force majeure provision, it will vary, but a standard provision will say something along the lines of a force majeure event means any circumstance not within a party's reasonable control, which will include, and it may go on to say without limitation, depending on the drafting, and then there'll be a laundry list of circumstances which will be taken into account. Two of the key circumstances which unsurprisingly have been focused on a lot recently is A, whether or not epidemic or pandemic has been included in the force majeure provision, and secondly, a common provision is any law or any action taken by a government or public authority. This one has been focused on because clearly where a government has suspended travel, has asked businesses or factories to close, it has had a very clear impact on the ability, particularly in the manufacturing sector, supply sector, for supply chain agreements. So look out for those types of provisions in the agreements. If you are a party to a contract and you receive from your counterparty a notice that the counterparty is invoking force majeure to not perform the agreement, what should you do? Before you accept that notice to suspend or delay the contract, you generally need to get comfortable that it's valid and does not constitute a breach of the contract. You will need to act very quickly to ensure you're not deemed to have waived your rights or acquiesced to the claim unnecessarily. Note that the fact that the counterparty is in financial distress will not of itself usually allow the party to invoke the force majeure provision. An invalid invocation of the provision and related non-performance of contractual obligations may constitute a breach of contract, for which, as mentioned before with the MAC provisions, a party may have right to damages and potentially also to terminate the contract. So the key points for you to consider if you receive one of these notices is A, confirm the notice is validly given in accordance with the contract. Pay particular attention to the format of the notice and the time within which the notice must be given, as these are often specified in the agreements. You'll need to get comfortable that the invoking party has provided adequate proof that the facts of the claim come within the force majeure provision and the definition has been satisfied. There's generally also a requirement for causation to be established, and that is the party invoking the provision would need to demonstrate that the force majeure event triggered the sort of hindering the prevention or the delay in the performance of the obligation. So that should be direct causation. Lastly, mitigation will also be a key consideration. Is there anything the invoking party could or should have done to mitigate or avoid the event or the consequences of the trigger event? So look closely at the facts in the round. You should also consider carefully the impact on the particular arrangement. For example, will this excuse one party's non-performance obligation, or does it bring the whole arrangement to an end? Also, is there a time limit for suspension of obligations? Will the agreement resume after a certain amount of time has expired? So they're the key points really in terms of force majeure provisions. Just the last point here on the slide is the question is this an opportunity to renegotiate? I just wanted to leave you with this point because we've seen many examples recently of parties to agreements which are facing difficulties given the current economic climate to take extraordinary steps to not strictly enforce contractual provisions where they may otherwise have a right to do so. So for example, providing extra time for satisfaction of payment obligations. We've seen parties renegotiating timetables for deliveries of goods in global supply chain agreements. And also we've seen a lot of parties amending agreements to allow them to adapt and continue on slightly different terms. So probably counterintuitive for a lawyer to say this, but we're urging parties to come to the table, take the opportunity to renegotiate when some of these unforeseen circumstances take control. So I have spoken over my time, as I mentioned, so I won't now touch on the defaulting limited partners section. I will hand over to Eloise to kick off on her section to cover insolvency from the onshore perspective.
Great, thank you, Jeremy and Michael. And just a reminder to everyone, please do feel free to send through any questions on the chat, and Jeremy and Michael can have a look at that while I'm speaking, so that if you have any questions for them, they can answer them at the end. So if, just seeing that the slides are loading, so if we can go through to the outline slide, the second slide when Tim has a chance. So Jeremy and Michael were more speaking about the situation if your client, your counterparty is in financial difficulty. And now we're kind of stepping to the other side of the table and thinking, what if the company that potentially you're advising or your company is in financial distress? So we're going to first discuss what insolvency is, then look at some more informal procedures, operational restructuring, informal and consensual restructuring, and then we'll move on to the formal processes, schemes of arrangement and winding up. I will be speaking about these from a Hong Kong perspective. There are similarities in some of the jurisdictions, for example, Hong Kong and Singapore. That said, Singapore has some added features in their scheme. But if you would like to know more about another jurisdiction we haven't discussed today, then please feel free to follow up with me or Jeremy and Michael. We can introduce you to our colleagues in those areas or make referrals to our contemporaries in other jurisdictions. So on to the next slide. So what is insolvency? There's two tests which are commonly used in many jurisdictions around the world, and in Hong Kong you can look from two perspectives. One is a balance sheet test, it's quite obvious in the name. This is where insolvency occurs because the value of a company's assets are less than the amount of its liabilities, taking into account both contingent and prospective liabilities. Whereas the cash flow test is that company is insolvent if it's unable to pay its debts as they fall due. We'll speak a bit about a compulsory winding up, which is also the type of winding up Jeremy was speaking about. And in a compulsory winding up, evidentially one of the easiest ways to get a winding up order is to prove that a company is unable to pay its debts. A very common way to do this is for a creditor to issue a company with a statutory demand. If there's no payment of that statutory demand within 21 days, then the court presumes that the company is unable to pay its debts. This is a presumption, so it can be disputed if the debt is genuinely disputed, but it just emphasises the importance. If you receive a statutory demand, don't ignore it. It's probably come across your desk because someone hasn't ignored it, so that's a good first step. But you may need to think about engaging external legal advice. You may want to start engaging with that creditor to discuss payment terms. So why do we care? If this company is insolvent, there are risks in continuing to carry on the business. That said, the risks in Hong Kong are not as burdensome as in other jurisdictions where there's insolvent trading provisions. Directors can be liable if the company does continue to trade while insolvent. It is slightly easier here in Hong Kong. That said, if transfers or monies are paid out of the company during that time and a liquidator is later appointed, then those transactions can be unwound or reversed. Also, if the company wants to continue in existence, it wants to continue trading, they will want to avoid a winding up action being taken by creditors. So it's important to look at the options to ensure that creditors that continue to be paid in full and they don't take these type of steps, and the current company can get out of its current position. So if we move to the next slide, operational restructuring. So this is really getting on top of your cash flow, understanding where you sit right now. Are you insolvent? Then thinking about ways of reducing your costs. Are there operational changes you can make in the way the company is being run to reduce those costs? Think about the employees, the premises that you have, any other fixed costs. Also, are there alternate revenue flows that could be investigated? A lot of businesses are thinking about doing things differently at the moment. There might be a new opportunity. Should also take advantage of any government stimulus packages that are available. So in Hong Kong, there's an employment support scheme, and I've included the link on the slides. Most people in Hong Kong would be aware of this. There is a timeline to apply. In this circumstance, there's a government grant to employers who retain employees who would otherwise be made redundant. In other jurisdictions, there's even more generous government stimulus. So if you can take advantage of those, then why not? I would say that during this stage is actually an important time to think about engaging a professional to assist you, to analyse your cash flows, help you make any operational changes, and plan for different scenarios coming out of the difficult economic times we're in. You might need to plan for different economic recovery outcomes. There is no new normal, or people don't know what the new normal is yet. You can't necessarily base it on past performance. Future performance may be different when consumer or customers' behaviours have changed. For example, the travel industry is one where we don't know if it will return to the same normal from before. Involving an external professional, an accountant, a financial advisor, a specific turnaround advisor can be helpful if you're making difficult decisions. Having a fresh set of eyes may bring new ideas, and they're able to draw on previous experience working in distress scenarios. So then moving on to informal and consensual restructuring options. I won't speak about this in too much detail because Michael has actually kind of flagged the main point, being in the current climate, various parties are open to renegotiate terms. So if the parties, the counterparties you're dealing with are open to that, why not investigate it? In relation to your financiers and your banks, can you negotiate new terms, lower interest rate, a different repayment schedule, a repayment holiday? It is important to think carefully if you are considering taking on further debt, as that may make your financial position more dire than it currently is. Similarly, with landlords, is reduction of rent possible? Are they amenable to an early release from a property? And the same applies with other creditors, and that's where Michael spoke about that bit already. So moving on to schemes of arrangement. What we've spoken about thus far is more informal ways of restructuring. And ultimately, if you want to reduce your debts or compromise your debts, you could agree with 100% of your creditors a new arrangement. But in reality, it's always going to be very difficult to agree with 100% of people you owe money to all take a haircut. Hence, the scheme of arrangement can be quite helpful. In other parts of the world, there are specific regimes for corporate restructuring, rescue, reorganisation. You may have heard of administration in the UK, voluntary administration in Australia, or very common Chapter 11 in the US. These are formal restructuring processes. Hong Kong doesn't have an equivalent per se. The best we have is the scheme of arrangement, which was actually set up initially for, can be used for debt compromise or arrangement, but also for arrangements between shareholders. And the law in the statute is quite short, but there's a lot of precedents in the common law which we can look to see how they can be used. So the next slide, just some points about what is a scheme. Schemes are very common across various common law jurisdictions and can follow a similar form and often look to precedents in those other jurisdictions. It's not an insolvency process, which is actually helpful if you're going to have cross-default provisions with various agreements and you don't want to have an insolvency per se. They're often used to implement terms which require unanimity, which require 100%, and you can't get 100% agreement. It's a compromise between a company and its creditors. On the next slide, we'll go through the steps, but one of the important parts is the creditors meeting where they approve the scheme. Now, this is really the benefit, is at that meeting, you only have to have 75% in value and a majority in number of each class of creditors who are present and attend the meeting, whether that be in person or by proxy, agree to the terms. If those percentages agree, then all creditors in those classes are bound by the terms, regardless of if they said no or they did not participate. So often the company in financial distress will work with a majority group of creditors. Sometimes they form together in an ad hoc group, negotiate the terms, and when they're comfortable, they will be able to meet those majorities. Then they'll start the court process once they have the documents pretty close to fully negotiated, and then the process is used to push it through and bind or cram down on those minority. So on the next slide, talked about some of the steps here. I think the key thing is that ultimately what the company and the creditors agree can be very bespoke. There's a lot of flexibility on the terms of what they want to agree. So there can be a debt for equity swap. Creditors can compromise their claims, i.e. agree to take a lower payout, for example, 50 cents in the dollar or 20 cents in the dollar. You'll usually find for a scheme to go forward, you need some kind of investment or capital to come in for the company to continue on. You can have new shares issued, change the shareholder structure as well. So the first point I have there's no moratorium or stay under this process. So if you think there's going to be a troublesome creditor who seeks to wind someone up, then there's two options. You can engage with them to see if they're interested to enter a standstill agreement. One of the motivations for a standstill is you can offer them an incentive fee, say 1 or 2% of their debt, that they will get paid if the scheme is successful from signing up early to a standstill, agreeing not to take action. These are used quite commonly. If this isn't going to be possible, then in Hong Kong, you may apply to have a provisional liquidator appointed, which gives you a stay, which means that other parties can't take action. The provisional liquidator is there to get the scheme implemented or through, and then once the scheme is effective, then the company will return to normal business. So it doesn't mean the company will necessarily be wound up. There's a first hearing where the court agrees to summon the meeting. Notices are given to the creditors. They can then choose to attend the creditors meeting. The necessary majorities can be met. If they're met, then you proceed to a second hearing where the court just double checks that the terms of what's been agreed is fair. And normally it's considered fair if creditors will receive more from a scheme than in a liquidation scenario. So part of the evidence you would file is an analysis of a liquidation of the company, and say in a liquidation the creditors get 10 cents in a dollar, but under the scheme they're going to get 25 cents in a dollar. So objectively it seemed to be quite fair and a good outcome for them if they get more than they would have in a liquidation scenario. You can also release third-party guarantors, so say directors or subsidiaries that have given guarantees. They don't have to be a party, but they can be released from their obligations. And moving to the next slide. Foreign companies can use this process. So it can be used by a Hong Kong company, but it can also be used by a foreign incorporated company if they have a sufficient connection to Hong Kong. The court looks at a variety of factors when considering sufficient connection, including where the assets are, where the creditors are, where the management is, where directors are, and one that comes up quite often is where the company is listed. As many of you know, most Hong Kong listed companies are incorporated offshore, but then listed in Hong Kong. And the court, in a case called Winsway, which I was involved with, indicated that a listing itself constitutes a material connection with Hong Kong. If there's debt in a foreign, governed by a foreign law, for example, US law governed debt, then the company would make a Chapter 15 application. That is a foreign recognition application in the US to make sure that the scheme's terms are approved there. So you have to look at what jurisdiction, where your debt is, as to where the appropriate place to do the scheme, and then if you need to have it recognised anywhere. They're a very flexible process and can be used in cases involving multiple jurisdictions. That said, they're not cheap, and the business usually needs to be sizable enough to warrant the costs of the professional advisors, legal and financial, that would be involved. We did have some pre-questions about Chapter 11, which we won't discuss in detail given this is a US process, but as a comparison, I would say on the whole, schemes do work out to be considerably cheaper than Chapter 11 process because there's less court involvement. Jeremy, did you want to add something?
Absolutely, no, just going to pile on the schemes and just say that the Cayman schemes have an awful lot in common with the situation you've just been describing. It's slightly different, but virtually the same. And to back up what you were saying, we find the provisional liquidation wrapper to give a protection, the moratorium during the scheme, to be really useful. And it has a little bit of an off-putting name because it has liquidation. Apart from that, we find it's an excellent way of promoting the scheme and making sure there's the breathing space to put it through. So thank you.
Great, and there's a lot that we could talk about on cross-border, when you would choose, for example, Cayman over Hong Kong, where you might have to look for something from one of the court and have it recognised in the other place. And if anyone has any further questions on that, please feel free to follow up with Jeremy or I. So we'll just move on to the next slide, talking about winding up your company. Now, this is probably the last resort and the last thing you want to think about, but there may be reasons for doing so. So if we move to the next slide, when, where, how, and why, often it might be once all other options are exhausted, or under why, you might feel that the directors might feel they're unable to continue the business, they aren't able to successfully restructure, and they want to responsibly deal with the debts they're owed. Also, they might want a third party to come in and manage that organised wind down. And that's where a voluntary liquidation process would be very helpful. There's 3 types of liquidation or winding up in Hong Kong, and I'll touch on them on the next slides. Again, where you choose to wind up may be based on where the company is incorporated, or it may be where it has more of a sufficient connection, where it really physically is more connected to. So moving on to the next slide, we talked about this, I've mentioned MBL and CBL. So these are the 2 voluntary processes. MBL is only available where a company is solvent. So to use this process, the directors have to sign a certificate as to the solvency of the company. This certificate will say that the directors have made a full inquiry into the company's affairs and have formed the opinion the company can pay its debts in full within a specified period, that period being 12 months or less. Now, if a director signs that certificate without reasonable grounds, they are liable to a fine or imprisonment. And you find when you talk to directors about this, it really focuses their attention and they can be quite hesitant to sign a certificate. Also, later on, if it turns out creditors couldn't be paid within that time, it would be presumed that they did not have reasonable grounds. If there's any error in the certificate, the MBL will convert to a CBL. So an MBL, you only need to have 75% of the shareholders resolve to place the company into liquidation. You don't have to have any creditors meeting. The liquidators who are appointed will be those that are chosen by the shareholders. So it's a quick process, and it will be a liquidator of choice of the shareholders, but it's limited when you can use it. If you really are in financial distress, insolvent position, then it's not appropriate. CBL is the appropriate process. You don't have to have the certificate. It starts off with the shareholders deciding to appoint liquidators, but then there also will be a meeting of creditors, and the creditors have to agree for the liquidation, and then they also can nominate a liquidator. They can pick the same one, which will be very uncontroversial, but if they choose to have a different liquidator, the creditor's choice will prevail. So the next slide, we just mentioned compulsory liquidation. So this is the court appointed liquidator. This is what Jeremy was speaking about before. It's usually when a creditor who hasn't been paid petitions to wind up the company. There are other scenarios where it's used. Someone had in the pre-questions asked about just and equitable winding up. That is often used where there's an internal shareholders dispute that can't be resolved and the company can't continue on. But the most common way is when there's a creditor who's unpaid, which just emphasises again why it's very important to deal with a statutory demand properly if you receive one. The next slide is a helpful summary table about the different winding up processes and why you might pick one over the other. I guess the first 2 have a V for voluntary, so they're initiated by the company, whereas usually the compulsory or the court one is initiated by another party. With a compulsory liquidation, there is a period usually of months between the date the petition gets presented or filed at court and the date of the first hearing. So this means if you do receive or are notified of a winding up petition against your company, you do have a period to take legal advice, decide how you're going to deal with it before it comes before the court. So we don't have too much longer to go. The final 2 slides were just talking in a bit more detail about creditors' voluntary liquidation, as I see that to be the one that people would be most interested in. If We move to the second slide on CBL. So to the next slide. So after the shareholders pass a resolution, then you have a meeting of creditors, and then they can appoint the liquidators. Their choice will prevail, as I mentioned. The liquidators will then be appointed. They're there to collect all the assets and distribute these to the creditors on a pari passu basis. They're also there to investigate the actions of directors and transactions the company has entered into in the period leading to the winding up to the liquidation order. It's worth remembering liquidators are independent and they're bound by various ethical and statutory duties. They will exercise their professional judgment in making decisions in the best interest of all the creditors, including whether that's making further inquiries, investigations. They won't be dictated to by the people that nominated them. So a committee of inspection can also be formed, and this would be formed usually of the majority creditors. This allows them to have some involvement and oversight as to what the liquidators are doing. Certain powers liquidators can exercise by themselves, but others they need to go to the COI or the court for sanction. So, larger interested creditors would be quite interested to join that committee. So they're the main points that I wanted to touch on today. And we've just got a few minutes left. So if anyone has any questions, we can deal with them. Jeremy or Michael, were there any that you wanted to answer?
Yes, there was one that came in and well, I think it's a good answer. Someone's asked what if you prefer to have both control and realization of assets? Remember when I was talking about share charges, those are my two main kind of strategy planks as to which one was important. And well, there's mainly two options if you want control and also realization. Firstly, if your documents allow you, you could take possession and then you could exercise the power of sale. So you control the assets in the first phase, and then the second phase, you realize their value. That can be a difficult route because, as I said, the possession stage has complications, and then your sale stage is more difficult sometimes if you're doing it yourself. The other way to do control and realization simultaneously is to appoint a receiver. And that can be very swift, particularly if it's a contractual receiver. And of course, once they're in, they take control of the assets without you needing to take possession, and then they can just work towards realization in an orderly manner. So those are the two ways you can kind of overlap both of them. And it really depends on what's important on your particular assets.
I might just jump in quickly, Eloise, unless there's any questions you wanted to answer. We've received a couple of questions on the contractual outs piece that I was talking about. The first one that came in, there's an interesting question. If I receive a notice of force majeure, should I balance it as a matter of course unless it contains all of the elements, causation, mitigation, and timeliness? I think this one's really important. When you do receive a force majeure notice, we would always advise clients to take it very seriously. You should straight away send out a holding notice to reserve your position, because if you do nothing, you may lose the battle effectively on the basis of acquiescence or on a deemed sort of waiver of your rights to challenge the notice. So yeah, do send a holding notice reserving your position, and then you should look very, very carefully through all the various elements that we discussed, make sure the circumstances fit within the force majeure or not, as the case may be, and then respond in a more fulsome manner to either accept and understand the position that the other side is taking, or to push back and say, we don't agree, and these are the reasons why we believe you should be performing your obligations under the contract.
And it's probably worth adding to that as well. It depends what jurisdiction you're in and the precise terms of your clause, but it's not always going to be the case that they're required to give full details in the notice. It's normally required to at least identify the event, but they're not necessarily required under the relevant laws to actually provide all the information you would actually need to assess it. So I think, yes, absolutely, take advice on it, and probably trust your own assessment of whether there's been a force majeure event as your kind of key guider, rather than necessarily deciding how good a job the other side's done with the notice. But as I say, that it depends on your particular contract and your jurisdiction, but it's certainly another question to be asking at the time.
Thanks. I also just got an interesting question. How would a litigation or arbitration be affected by a winding up proceeding? Would the proceedings be stayed? Would the plaintiff, assuming the company being wound up as the defendant, be deemed as an unsecured creditor? So there's actually been quite a lot of case law on this in the last couple of years. Generally, once a winding up order is made, there is a stay on any proceedings, any litigation. What's quite interesting is the interplay between arbitration and winding up. If an arbitration is on foot and it relates to the debt in issue, normally the court won't make a winding up order because it says the debt is disputed, it's still being determined, and likely the contract said you must go to arbitration first. That said, in circumstances, courts will make the winding up order, because a winding up order is something that only a court is capable of making. An arbitral body cannot make an order to wind up a company. So even if the agreement requires arbitration, if it's appropriate, the court may still make the winding up order. And there's been some cases where a company has had a winding up petition issued against it, and it's tried to dispute or contest the winding up order, saying, well, I've got an arbitration clause, this it's disputed, and therefore you shouldn't make the winding up order. But the court has said, no, if no one's actively pursuing the arbitration, you can't just kind of keep it on hold forever because there's an arbitration clause. And in those circumstances, the court has made a winding up order. But there has been some cases, even appeal cases in the Court of Appeal in the last couple of years here in Hong Kong. And I know there's also been some discussion of this in Singapore by the courts recently as well. So we're actually coming to the end of the hour, unless there were any questions you wanted to quickly jump in with, Jeremy or Michael. Was there any final points?
Well, we're very lucky to have had a huge number of questions, but I think probably we should respect the time limit. So perhaps we could go back to those directly. And obviously, as we said, feel free to approach any of us by email to follow up with your questions or for any other questions, and we'll try and get back to everyone. But I think probably we should hand back over. So over to you.
Thank you so much, Eloise, Jeremy, and Michael. Again, echoing what Jeremy just said, if you have any further questions, please email them directly to Eloise, Jeremy, and Michael. Will share their email IDs with you in the next email that you all receive. And also thank you very much to Carrie Olson and Stephenson Harvard for co-hosting this webinar with us. Remember to fill in the survey that will pop up once I close this webinar. And thank you very much for taking out the time, and we'll see you in the next one. Bye.
Thank you very much for having us speak as well, and thank you for organising, Rahul.
Thank you very much. You're welcome.
Thank you very much, Rahul.
Goodbye.
Bye-bye.